Hi, this is Dr. Ishita Sharma, and in today's lecture, we are going to discuss the concepts of res ipsa loquitur in the light of contributory negligence and composite negligence. I hope it turns out to be an interesting ride. Now students, let's start with an introduction to the topic. Res ipsa loquitur is a Latin phrase which literally translates to the thing speaks for itself. An essential part of any personal injury case is being able to show that the other party's wrongdoing or negligence caused the injury at issue. Sometimes an injured party is unable to show direct evidence of negligence, but fortunately, California's doctrine of res ipsa loquitur means that circumstantial evidence may be sufficient if the injury was of the sort that would not normally occur absent negligence. Now, what is the purpose of this doctrine? The doctrine of res ipsa loquitur lets an injured person present a prima facie case of negligence even when there is no specific evidence that the defendant party was negligent, or when only the defendant has access to the evidence of negligence. An injured person, however, may not use res ipsa if he or she has access to direct evidence of negligence. The use of res ipsa is common in medical malpractice cases, in which injured patients often do not have access to evidence of a medical professional's negligence. That can be illustrated through an example. It may be used to show that a physician was negligent while performing a surgery while the patient was unconscious and thus unable to observe or collect any evidence of negligence. Now let's come on to the elements of res ipsa loquitur. To prove a res ipsa loquitur claim, an injured party must show three elements. Number one, that the accident was of a sort that does not normally occur without someone's negligence. Second, that the accident was caused by an instrumentality within the defendant's exclusive control. And lastly, third, that the accident did not happen due to any voluntary action by the injured party. First, the type of injury must be the sort that does not ordinarily happen if the defendant takes proper care. Again, through an example, a man injured himself when a restaurant's counter stool fell on its base. Under ordinary circumstances and when used normally, stools do not fall apart without some negligence. Secondly, the object causing the accident must have been within the sole control of the defendant party. Now, in the earlier mentioned stool case, the stool was in the exclusive control of the restaurant that owned it. Finally, the accident must not have occurred because of the injured party's voluntary actions or contributions. Again, the stool case, the man in that case sat on the stool in an ordinary fashion, tilting it only about an inch. Thus, all the three requirements for res ipsa loquitur were satisfied in the case, and the doctrine applied. The difficulty in res ipsa cases is usually showing the defendant's exclusive control. Let me illustrate that through another case. A woman was walking on the sidewalk adjoining a hotel when she was hit on the head by an armchair that fell out of a window of the hotel. She brought a res ipsa suit against the hotel. Though being hit by a falling armchair is the sort of accident that does not ordinarily occur without negligence. And though the woman's actions did not contribute to the injury, her res ipsa claim failed. Why did this happen? This was because the hotel did not have exclusive control over the furniture in its rooms because it gave partial control to its guests. Now let's come onto the concept of composite and contributory negligence under the law of torts. Contributory negligence refers to the ignorance to take due care on behalf of the plaintiff to avoid the consequences resulting from the negligence of the defendant. Therefore, the liability of negligence lies on both the plaintiff and the defendant. This concept entered the legal world in 1809 because of the English case of Butterfield versus Forrester, which is considered to be the beginning of the application of the defense of contributory negligence. The plaintiff sustained injuries when his horse collided with an obstruction on the road, which had been left by the defendant during home repairs. It was later discovered that the plaintiff was negligent as well and was riding the horse at a considerably fast pace. Although the defendant's negligent conduct was a significant cause of the plaintiff's injuries in court, it was held that under such circumstances, the plaintiff should be absolutely barred from compensation, as he failed to take proper caution while riding. There are three theories that are commonly used to determine the application of the defense of contributory negligence in a particular case. These theories are: number one, the proximity of legal reasoning, such as the foreseeability and proximity to the negligence of different torts. Number two, indemnity or the contribution of damages given by joint tort feasors. Number three, a voluntary assumption of risk as given in the maxim volunti non fit injuria. In the case of Davies versus Swan Motor Company, Davies had been standing on the steps at the side of a dust truck, which was a dangerous place to stand, when the truck was traveling along a narrow road and a bus tried to pass the truck. Davies was unfortunately killed. The court held that Davies was himself 1/5 responsible for the damage because of his negligence in standing on the steps or being upon the side of the dust truck. His damages were accordingly reduced under the Law Reform Contributory Negligence Act of 1945. In our nation, the term composite negligence refers to both types of cases, independent tortfeasors and joint tortfeasors. The tortfeasor's responsibility under composite negligence is joint and many. In such a case, arguing for the apportionment of damages and basing one's obligation on their fault is not permitted. The judgment rendered against the composite tortfeasors is for a single sum without apportionment, and the plaintiff has the option of enforcing the entirety of his claim against any one of the defendants. If one defendant has paid more than his fair share, he may seek reimbursement from the other defendants. Two passenger buses collided in the case of Karnataka State Road Transport Corporation versus Krishnan, resulting in severing of the left hands of two passengers on one of the buses below the shoulder joint. The current incidents are certainly cases of composite carelessness, the court said. As a result, both drivers are jointly and severally accountable for the compensation. Now, coming to the apportionment of damages for contributory negligence. Knowledge of all facts of the case is required for allocating damages and understanding the type of injury suffered by the plaintiff, which includes knowing all of the plaintiff's losses as well as physical and mental injuries due to the accident. The degree of liability or negligence of each party is a question of fact and is determined either by the jury or the trial judge, as the case may be. Once this has been identified, it must be proven that the injury is a consequence of the actions of the defendant. Establishing this aids in identifying the number of tortfeasors or defendants that are potentially liable to pay damages to the plaintiff. The apportionment of damages also requires consideration of other factors, such as the nature of the duty owed by the defendant to the injured plaintiff, and most importantly, the timing of different acts of negligence and the number of acts of fault or negligence committed by the person at fault. When the plaintiff performs or does not perform particular acts to reasonably protect himself from a foreseeable accident, this negligent behavior results in more chances of injury due to the negligent acts of others and is classified as an act of contributory negligence by the court. Contributory negligence results in the plaintiff being barred from recovering damages relative to their degree of fault, making it non-compensatory in nature. In cases where the defense of contributory negligence is used after successfully proving the negligent behavior of the plaintiff, compensation, that is, to be awarded for injuries to the plaintiff, is not awarded according to the original rule of contributory negligence. There have been recent changes in this rule, such that the compensation given to the plaintiff is relatively reduced by the same degree that the plaintiff is found to be at fault. This is also known as comparative negligence in many countries. Hence, if the plaintiff is found to be at fault for 30% of the accident, then the compensation for damages is reduced by 30% as well. Now, let's come on to the exceptions to the defense of contributory negligence. Contributory negligence is not available as a defense in tort when it is not necessary for the plaintiff to take due care. However, on the other hand, the defendant is legally obligated to perform the duty of care. The failure to perform this duty of care results in the liability of negligence for the defendant. Let's illustrate this through an example. Person X is traveling on a bus with his sister. In order to show her something on the streets outside, X got up, placed his hand on the window, which all of a sudden flew open and broke. Although X could have avoided the accident here, but the state bus transport service has a legal duty to have properly screwed windows and doors, which would prevent such accidents for the safety of the passengers. The concept of contributory negligence is a defense for acts of negligence and is never applied to intentional torts such as assault or battery. From this arises its first exception, that contributory negligence is not a defense where the defendant's conduct is so aggravated that it can be characterized as willful, wanton, or reckless. In cases where the plaintiff has similar conduct with wrongful intentions, the plaintiff is barred from any compensation as well. Another exception to contributory negligence is when the defendant's actions lead to a violation of a statute of law. Again, an instance. A violation of the Child Labour Act by the defendant places the entire responsibility of the wrongful act on the defendant and protects the plaintiff from the consequences of his own negligence. In the case of contributory negligence, the plaintiff who has himself contributed to the accident cannot claim remedy for the injuries sustained by him in the same accident to the degree of his own negligence. Whereas, in the case of composite negligence, the plaintiff who has suffered injuries has not contributed in any way to the accident, but the injury is due to the consequences of the combination of the negligence of two or more people. In cases of contributory negligence, the injured person is not required to establish the extent of responsibility of each wrongdoer separately, whereas it is required to do so in cases of composite negligence. Under composite negligence, each wrongdoer is severally and jointly liable to the injured plaintiff for the remuneration of damages, and the plaintiff has the option of taking legal action against all of the defendants or any one of them. It is only in cases of contributory negligence that the injured person has contributed to his own injuries, whereas in cases of composite negligence, the plaintiff is not responsible for his injury or losses. Now let's come on to the concept of comparative negligence. Comparative negligence. is a partial defense in tort cases. If an accident victim wants to sue someone who harmed them, the defendant can claim comparative negligence to reduce the plaintiff's recovery. The injured victim can file a personal injury claim if someone else causes them harm. If the victim is able to prove that the defendant breached a legal duty and damaged them as a result, the victim can recover financial compensation for losses. Defendants accused of wrongdoing can raise defenses though, and comparative negligence is one of those defenses. Under the legal doctrine of comparative negligence, a victim who was partly responsible for the incident that led to harm can only recover part of their damages. And in some cases, they cannot recover at all, depending on how much of the blame lies with them. Now comes the last opportunity rule, or the rule of last clear chance. This was a theory that evolved in cases of contributory negligence in personal injury cases. Negligence in general refers to an act or omission on the part of the defendant in a tort claim, in breach of a duty of care owed by him or her to the plaintiff, that causes injury to the plaintiff. A defense to a claim of negligence that is available to the defendant is that of contributory negligence. The plaintiff's act or omission that caused the injury is referred to as contributory negligence. In such cases, if contributory negligence is proven, the liability for the incident is no longer solely on the defendant's shoulders. Now let's see the application of this doctrine in Indian jurisdiction. In Jung Bahadur Singh versus Sundar Lal Mandal and others, the plaintiff, that is Jung Bahadur, was the owner of a horse and was standing on the left side of the road with the horse to his left, close to a ditch. The bus driver, the defendant in this case, was driving at a rash speed on the wrong side of the road. The last opportunity rule was applied in this case, along with several other principles. The defendant had the last opportunity to prevent the collision, apart from the fact that the plaintiff was not in a position to move further left because he was standing by a ditch. The Patna High Court upheld the decision of the subordinate court. Winfield's opinion on the last opportunity rule was quoted as calling it illogical. Lord Denning's remarks were quoted from another case, Jones versus Livox Queries, where he was quoted as saying that despite the irrelevance of the last opportunity doctrine, the problem of determining causation still remains. In the above case, it was decided that the defendant was negligent and that the use of the doctrine in question did not arise. Indian jurisprudence seems to follow in the footsteps of its English counterpart in rejecting the doctrine. Now, concluding all the aforementioned concepts that we have discussed, one can conclude that contributory negligence is a defense in tort that is available to the defendant, which limits the plaintiff from receiving the total compensation or remedy. It is the omission of an act or ignorance to take care to avoid injuries due to the negligence of other tortfeasors. Deviations from the concept of negligence in the form of defenses and rules such as composite negligence, contributory negligence, and comparative negligence are all systems used to calculate the appropriate amount of damages to be awarded to the plaintiff. With this, we come to the end of today's lecture. I hope you understood the concepts. Thank you very much.